Mounting frustration this morning among members of Congress and survivors of sex offender Jeffrey Epstein after the Department of Justice failed to release all the Epstein files by a Friday deadline required by law.
They're flouting the spirit and the letter of the law, and I won't be satisfied until the survivors are satisfied.
The House Republican and Democrat who've led the charge on forcing the documents' release now threatening to hold Attorney General Pam Bondi in contempt or impeach Justice Department officials, pointing to the thousands of documents still not released and hundreds of blacked out, redacted pages.
The courts are going to find that these were excessive.
Deputy Attorney General Todd Blanche defending the document rollout in an interview with NBC's Kristen Welker.
We're going through a very methodical process with hundreds of lawyers looking at every single document and making sure that victims' names and any of the information from victims is protected and redacted.
Blanche addressing outcry over photos and documents posted and then removed, including this one with an image of President Trump alongside photos of several women that the Justice Department later reposted.
We learned after releasing that photograph that there were concerns about those women and the fact that we had put that photo up. So we pulled that photo down. It has nothing to do with President Trump.
The DOJ underscoring that no redactions were made to protect prominent people, while a group representing survivors called the release a step backward for transparency and accountability. In Washington, Alice Barr, NBC News.
On November 19th, 2025, Congress passed a law with a very specific deadline. The Epstein Files Transparency Act required the Department of Justice to release all unclassified records related to Jeffrey Epstein, investigations, prosecutions, plea deals, travel logs, immunity agreements, internal communications, everything within 30 days. That deadline was December 19th, 2025. The Trump administration missed it. They didn't ignore it completely. They created a website. They posted some documents. They called it the Epstein Library. But what they released was incomplete, heavily redacted, and according to multiple news outlets, some files that were briefly posted disappeared within hours. DOJ officials acknowledged publicly that the release wouldn't be complete by the deadline. They said materials would continue to be published on a rolling basis, which is another way of saying we'll get to it when we get to it. And here's the thing that should alarm anyone who cares about the separation of powers. Congress has almost no way to enforce its own law. They can complain. They can hold hearings. They can issue strongly worded statements. But if the executive branch decides to slow walk compliance, to bury transparency under the language of phased releases and ongoing reviews, there's remarkably little Congress can actually do about it. This isn't just about Epstein. This is about whether congressional mandates mean anything when the administration in power decides they don't. So let's decode what happened, what the law actually requires, and why the Trump administration's partial compliance is a much bigger problem than it might seem. Let's start with what Congress passed. The Epstein Files Transparency Act, Public Law 11938, is unusually clear. It doesn't give the Attorney General discretion about whether to release records. It doesn't suggest they consider it. It requires publication within 30 days of enactment. The law covers all unclassified records in the possession of the Department of Justice, including the FBI and U.S. Attorney's offices, related to Jeffrey Epstein. That includes investigations, prosecutions, plea agreements, non-prosecution agreements, immunity deals, travel logs, detention records, documentation of his death, and internal DOJ communications about the case. The materials have to be published in a searchable, downloadable format, and the statute includes something critical: an anti-cover-up clause. The DOJ cannot withhold, delay, or redact documents due to embarrassment, reputational harm, or political sensitivity, including embarrassment to government officials or public figures. That language is there for a reason, because Congress knows how agencies bury things. They classify information that doesn't need to be classified. They redact names to protect sources and methods that don't actually need protecting. They claim documents are part of ongoing investigations that have been closed for years. So the statute tries to close those loopholes. It says, you can't hide this stuff just because it makes someone look bad. Now, the law does allow some redactions: victim privacy and personally identifiable information, child sexual abuse material, legitimately classified national security information, active criminal investigations, certain graphic content. Those are reasonable. No one wants victims' names published. No one wants illegal images circulating. But the statute requires DOJ to provide written justifications for any redactions. And when the full release is complete, DOJ has to report to Congress explaining what was redacted and why. The whole structure of the law is designed to prevent exactly what happened: partial compliance dressed up as transparency. On December 19th, the Justice Department launched the Epstein Library. It's a web page with a search interface and a DOJ disclosures section where users can browse and download files. The site includes a disclaimer that redactions were made to protect victims' personal information and other sensitive content. And it asks the public to report any inadvertently posted sensitive material. Sounds responsible, right? Except here's what reporters found. The Associated Press reported that at least 16 files disappeared from DOJ's public webpage within a day of being posted. No explanation, no notice, just gone. CBS, Reuters, and other outlets described the release as incomplete and heavily redacted. Major sections blacked out. Key documents missing. Travel logs fragmented. Internal communications sparse. And DOJ officials told reporters on the record that the release wouldn't be complete by the deadline, that materials would continue to be published over time, on a rolling basis, which raises an obvious question. If you knew you couldn't meet the deadline, why didn't you ask Congress for an extension? The law was passed on November 19th. DOJ had 30 days. That's tight, but it's not impossible for a federal agency with thousands of employees and unlimited resources. And if it genuinely wasn't enough time, the Attorney General could have gone to Congress and said, we need 60 days or 90 days. Here's why. They didn't do that. Instead, they just didn't comply, and then framed partial compliance as if it were the same thing as meeting the statutory requirement. Let's decode the language DOJ is using to justify this. They're calling it a phased release, a rolling basis, ongoing review. Those are process words. They sound bureaucratic, technical, like this is just how large-scale document production works. But here's what those words actually mean. We're going to release what we want, when we want, at whatever pace we decide. That's not what the statute says. The statute says 30 days. It doesn't say begin releasing within 30 days. It says publish the records. DOJ is also leaning heavily on victim privacy as a justification for delay and redaction. And that's clever, because who's going to argue against protecting victims? But the statute already accounts for victim privacy. It explicitly allows redactions for personally identifiable information. So invoking victim protection as a blanket excuse for incomplete compliance is rhetorical misdirection. It conflates legitimate privacy concerns, which everyone agrees with the administration's decision to slow walk the release and heavily redact documents that have nothing to do with victim identification. This is a classic manipulation tactic. Take a sympathetic rationale and stretch it to cover actions it doesn't actually justify. The law says you can't redact for political sensitivity or embarrassment. So if DOJ is redacting names of public figures who aren't victims, or blacking out internal communications that reveal investigative failures, or withholding travel logs that don't contain victim information, that's not victim protection. That's cover. And when files disappear from the website within hours of being posted with no explanation, that's not a phased release. That's concealment. Let's step back from the specifics of this case and talk about what's actually at stake here. Congress passed a law. The president signed it. It became binding federal statute. And the executive branch, the same branch responsible for enforcing laws, decided to comply on its own terms, at its own pace, in whatever manner it deemed appropriate. That's not how the separation of powers is supposed to work. Congress makes laws. The executive enforces them. The judiciary interprets them. Each branch has tools to check the others. But what happens when the executive just ignores a congressional mandate? In theory, Congress can hold the Attorney General in contempt. They can subpoena documents. They can file suit in federal court to compel compliance. In practice, all of those remedies are slow, uncertain, and politically fraught. Contempt proceedings take months. Court cases take years. And even if Congress wins in court, enforcement depends on the executive branch, the same branch that's refusing to comply in the first place. This is what's called a delay as veto. The administration doesn't formally reject the law. They just slow roll it to the point where compliance becomes meaningless. By the time the full release happens, if it ever happens, the news cycle will have moved on. Public attention will have faded. The documents will trickle out over months or years, fragmented and heavily redacted, with no coherent narrative and no accountability for what took so long. That's not transparency. That's theater. And the precedent it sets is dangerous. Because if the Trump administration can ignore a statutory deadline on Epstein files, what stops them from ignoring deadlines on anything else? What stops them from slow-walking Freedom of Information Act requests, from burying congressional subpoenas under claims of executive privilege, from redefining statutory obligations until they're optional? This is how executive power expands, not through dramatic confrontations, through procedural non-compliance, through treating congressional mandates as suggestions. Let's talk about why the Trump administration made this choice. Because it was a choice. They could have complied. They could have met the deadline. They chose not to. And the calculation seems pretty straightforward. The cost of non-compliance is lower than the cost of transparency. What's the cost of non-compliance? Some bad press, some congressional complaints, maybe a contempt vote that goes nowhere, maybe a lawsuit that drags on for years. What's the cost of full transparency? Unknown. Because no one knows what's in those files. Maybe there's nothing. Maybe it's all routine investigative material that doesn't implicate anyone significant. Or maybe there are names, logs, communications, internal memos that reveal investigative failures, dropped leads, or political interference. The Trump administration doesn't know. But they know that once the files are public, they can't take them back. They can't control the narrative. They can't decide what gets emphasized and what gets buried. So they're choosing delay, partial releases, redactions, a rolling basis that lets them shape the story over time. And they're betting that Congress won't or can't do anything about it. So what are the enforcement mechanisms? Congress could hold Attorney General Pam Bondi in contempt. They could vote to refer her to the Justice Department for prosecution. See the problem? You're asking the Justice Department to prosecute its own boss for refusing to comply with a law about the Justice Department's records. That's not going to happen. Congress could sue in federal court to compel compliance, but that takes time. And even if they win, the remedy is usually an order directing the agency to comply, which the agency can then slow walk all over again, claiming they're working on it. Congress could hold hearings. They could subpoena documents. They could demand testimony from DOJ officials about why the deadline was missed. And DOJ officials will show up and say, "We're working as fast as we can. We're protecting victims. We're conducting ongoing reviews. We're committed to transparency." And then they'll go back to the office and continue releasing documents at whatever pace they choose. This is the weakness of congressional oversight when the executive controls enforcement. All of Congress's tools depend on either voluntary compliance or judicial intervention. And both of those take time. Time the administration can use to drag things out until no one cares anymore. Let's come back to the detail that's most troubling: files disappearing from the DOJ website. According to the Associated Press, at least 16 documents that were briefly available on the Epstein Library webpage vanished within a day of being posted. No announcement, no explanation, just gone. When reporters asked about it, DOJ didn't provide a clear answer. They said they were reviewing materials, that they might have inadvertently posted something sensitive. But here's what that means in practice. The public had access to certain documents for a few hours, and then those documents were taken away. And we don't know why. We don't know what was in them. We don't know if they'll ever be reposted. That's not transparency. That's the opposite of transparency. It suggests that someone reviewed the initial batch of releases, saw something they didn't like, and pulled it. Maybe it was legitimately sensitive material that should have been redacted. Maybe it was a victim's name that slipped through. That's possible. Or maybe it was something embarrassing, something politically sensitive, something that contradicted the official narrative. We don't know, and that's the point. When an agency releases documents and then yanks them without explanation, it destroys public trust in the process. Because if they can make files disappear once, they can do it again. And how many files were never posted in the first place? Here's what this all adds up to. The Trump administration treats transparency as a threat, not a principle. Whether it's blocking congressional access to immigration detention facilities, which we talked about earlier, or slow-walking Epstein file releases, or fighting FOIA requests, or asserting executive privilege over everything, the pattern is consistent. When oversight threatens to reveal something uncomfortable, the response is delay, obstruction, and procedural gamesmanship. They don't say no outright. They just make compliance so slow, so partial, so redacted that it becomes meaningless. And they do it using the language of responsibility, victim protection, national security, ongoing investigations, phased releases. It all sounds reasonable until you realize that none of it is required by law, that the statute explicitly prohibits exactly this kind of delay, that Congress anticipated these excuses and tried to foreclose them. The administration is counting on two things. First, that the public won't read the statute and won't realize that what DOJ is doing violates its plain language. And second, that even if people do realize it, they won't be able to do anything about it. And so far, they're right. Let me be very clear about something. This video is not about conspiracy theories. It's not about speculation. It's not about who might or might not be implicated in Jeffrey Epstein's crimes. This is about whether Congress can pass a transparency law and have it mean something. The Epstein Files matter because of what they might reveal about investigative failures, prosecutorial decisions, immunity agreements, and institutional accountability. They matter because a wealthy, connected man was able to abuse dozens of people for years, and when he was finally prosecuted, he got a deal so lenient it became a national scandal. The public has a right to know how that happened. Who made those decisions? What pressure was applied? What opportunities were missed? Congress agreed. That's why they passed the law. And the Trump administration, despite the law, despite the deadline, despite the explicit prohibition on withholding documents for political sensitivity, is preventing that transparency from happening. That should bother you, whether you think Trump is implicated or not, whether you think Clinton is implicated or not, whether you think anyone specific is implicated or not, because the principle at stake is bigger than any individual. It's about whether the executive branch can simply ignore laws it finds inconvenient. And right now, the answer is yes, they can. The DOJ says they'll continue releasing documents on a rolling basis. Maybe they will. Maybe over the next few months, more files will appear on the Epstein Library website. Maybe some of the redactions will be lifted. Maybe the missing documents will be reposted. Or maybe the releases will slow to a trickle. Maybe the redactions will remain. Maybe the files will stay buried under claims of ongoing review and victim protection. We don't know. And that's the problem. Because transparency shouldn't depend on the executive branch's goodwill. It shouldn't require trusting that they'll eventually get around to complying with the law. Transparency should be the default. Compliance should be mandatory. And when Congress passes a law with a date-certain deadline, that deadline should mean something. But it doesn't. Not anymore. The Trump administration has calculated that the political cost of defying Congress is lower than the risk of full disclosure. And unless Congress finds a way to impose real consequences, not just hearings and press releases, but actual penalties that hurt, that calculation will keep being correct. This is a test of the separation of powers. And right now, Congress is failing it. Not because they don't want to enforce their law, but because the tools they have to enforce it are weak, slow, and depend on cooperation from the very branch they're trying to check. That's the structural problem, and it's not going away. Here's the uncomfortable truth about all of this. We live in a system where laws are supposed to constrain power, where Congress makes the rules and the executive follows them, where transparency is a check on abuse. But all of that only works if the people in power believe in it, if they see legal obligations as binding, not optional, if they treat congressional mandates as something more than suggestions. The Trump administration doesn't believe in that, or at least they don't act like they do. They believe in power, in doing what they can get away with, in testing the limits and seeing who pushes back. And when the pushback is weak, when it's just press releases and committee hearings and lawsuits that take years, they keep pushing. That's what's happening with the Epstein files. That's what's happening with immigration detention oversight. That's what's happening across the board. The administration is redefining what compliance means. They're turning mandatory deadlines into aspirational goals. They're treating transparency laws as if they contain an invisible asterisk that says, unless we don't want to. And they're doing it because they can. Because Congress is structurally weak when the executive refuses to cooperate. Because the courts are slow. Because public attention is short. And because most people won't notice, won't care. won't even know that a law was passed, a deadline was missed, and nothing happened. But you should notice. You should care. Because the next time Congress passes a law about anything, the executive branch will remember what happened here. They'll remember that they can miss deadlines, that they can release partial, redacted materials and call it compliance, that they can make files disappear and face no real consequences. And they'll do it again. That's the precedent being set right now. Not in some dramatic constitutional crisis, just in the quiet procedural noncompliance with a transparency law about a dead predator's files. Congress passed a law. The Trump administration ignored it, and there's almost nothing they can do about it. That should terrify you, because if they can do it with this, they can do it with anything.
Thanks for spending a few minutes digging into this with me. If you want more grounded, progressive commentary without the outrage bait, subscribe and stick around. Every time you watch, share, and engage, it helps build a community that believes democracy is worth understanding and defending. I'll see you in the next video.